Okay, hello everyone. Welcome to the Truth Legal Business Services webinar, all about the Employment Rights Bill. It's going to be hosted by Navia and Mirek, people who work at the firm, and I hope you get all your questions answered for you today. Can you take it away, Navia?
Hello, everyone. I'm Navia Shekhar, and I'm a director at Truth Legal, and I'm also head of employment. I've got many years of experience doing employment law, and I hope to be able to assist you here today with the Employment Rights Bill. James, I understand we've got a few more people who are due to join us. Shall we wait for 2-3 more minutes before we start?
Yeah, can do. Yep.
Okay, is that okay with everyone that we wait for others to join for a couple more minutes and then we can kickstart the webinar? Today's webinar, though, would be we will have James, who you all met, and he will be assisting us with question and answer and any other elements that need to be where we may need any assistance. My colleague Mirek will also join me in delivering the webinar, and he's our litigation executive who's worked with me in our employment team for over 10 years. Mirek, do you want to introduce yourself while we're waiting for others to join?
Yes, hello everyone, welcome at our webinar. Hopefully more people will join. Yeah, I've been working for Truth Legal many years, over a decade. I appear very often at employment tribunal hearings, so I think we can also discuss the practicality of the proposals of the new Employment Rights Bill and how these will implicate you as employers and us as lawyers and probably employment tribunals and everyone else in this new situation that is coming pretty soon.
Yeah, so in this presentation, we are going to address 4 main questions before opening the floor to some questions. So please, make a note of any questions that you may have, or if you've got, any queries, then we can address them at the end when we open the floor for questions. Those questions, the issues that we'll be addressing at this in this presentation will be: what is this bill? When is this bill? What is in this bill, and how will this affect us as employers? Mirek, up to you.
Yeah, so that as I said, the bill is coming pretty soon. It's already been discussed, and first readings in the Parliament has been completed. But I think the last reading would be around autumn 2025, and the bill will be implemented in somewhere around 2026. We don't have any concrete dates yet. But that's when you look at the dates, that's what we're looking for, more or less.
Also, this bill is only going to be limited to England and will affect England, Scotland, and Wales. It will not be impacting Northern Ireland. So when is this bill? As you can see, on the timeline, we're not at the end of this bill's legal development. It's still going through consultation. So once it finishes consultation, that's when it will hopefully become, well, I'm saying hopefully, I don't think it will be dropped, but it will, there are a lot of changes that may happen during the consultation period. And, we want to be really ahead of this, the changes that is coming. So the whole purpose of this presentation is to make you aware of what changes we're expecting and where do we see ourselves by the time this bill comes in force. We want to be prepared rather than having stressful nights just when the bill is announced to be implemented. Mirek, up to you.
Yeah, can we move to the next slide, please, James? Yeah, so these we listed the main areas of the law, the subject that within the new employment rights bill will be changed. So we'll try to show you the sort of comparison, the difference between what we have now and what is going to be changed in near future. Not everything will be changed, but in my view, majority of the most important obligation and rights will be one way or another affected. Okay, so to go. Okay, so we just move. We stay on the unfair dismissal and probationary period. So the first two main important changes will largely be around the rights to claim unfair dismissal. So the current situation is employee must have a minimum 2 years of service. So if someone has got less than that, let's say 18 months, they don't have right to claim unfair dismissal unless some exceptions can be applicable, like discrimination or whistleblowing. So the new proposal is that the right not to be unfairly dismissed would be from day one. Obviously, I think already many employers and lawyers have seen this as a bit it need to be clarified because there will still need to be a probationary period. So you don't know an employee within 1 day. So the bill most likely will imply about 90 days of probationary period. It can be probably extended, so we don't know yet what will be the exact wording of the new proposal, but definitely it will not be 2 years.
Okay, so I mean, Mirek has just touched upon unfair dismissal day one right. Whilst day one right will come into force, it will, it would still there will be ways and means by which an employer can lawfully dismiss and fairly dismiss employees if they are not suitable for the organisation. As Mirek has touched, probationary review. Probationary period is likely to be there'll be some provisions in relation to that. Then comes the changes in relation to collective redundancy and and restructuring. So at the moment, the way the law is that if you've got 20 or more people at one establishment, then there are only then there is a need for collective redundancy. However, this is going to change going forward. We don't know exactly what will be the position, but it has been floated that it will depend on the percentage of the workforce being impacted, and what would be applied perhaps would be that there'll be a percentage applied in order rather than a strict 20 people. The other thing that happens in a restructuring and or a redundancy situation quite often, or otherwise as well, is fire and hire. At the moment, fire and hire is lawful. However, it is sometimes frowned upon within the industries, generally. The new bill proposes that hire and fire will no longer be lawful unless there are certain exceptions that are applied. So we will have to wait and see what the government comes back with, but it is no longer going to be, as we suspect that it is no longer going to be lawful for employers to terminate employment of employees who are refusing to accept changes to the terms and conditions of their employment. And once that happens, if they're dismissed for that reason, then it would be deemed as unfair dismissal. Also, there is another element about outsourced public service contracts. And at the moment, a lot of public service contracts, when it is taken over by private sector, employees from public sector may to be transferred to the private sector. And the terms of public sector contracts tends to be public service contracts, employees who have been employed by the public sector tends to be much more robust than what private sector offers. And there tends to be a difference between the terms and conditions of ex-public sector employees and that of private sector employees. I'm not sure how the government is looking at bridging this, but this will no longer, the differential will no longer be able to exist. So I would suspect that a lot of public sector contracts may not go to private sector going forward, given that a private sector may not be able to sustain the cost of the terms and conditions that are being offered by the public sector to the ex-public sector. The terms and conditions that ex-public sector employees have it will be difficult for private sector to match that, their private sector employees' salary and terms and conditions to the public sector employees. So I don't know how the government is going to play this as TUP restricts changes to existing contractual terms. So we will have to see how it plays out, but I suspect that there will be less movement. Mirek, over to you.
Yeah, so the next change will be the 0-hour contracts. So for now, the current legislation is that this can be quite ongoing situation of the 0-hour contract, and also if there is no shift, no hours available, then it is very easy for the employer to just, for example, telephone the workers or employees and tell them, we don't require you for today or for tomorrow or for this week. While the new legislation, the main change will be that that's what the proposal is. Over up to 12 weeks, there will be more fluency and more, the shifts can be cancelled, but after 12 weeks, if there is a pattern established of regular shifts, regular hours, certain hours will have to be guaranteed to the employee or a worker. So the 0-hour contracts would not would need to reflect the true situation. So I think, in my view, from my experience, is that because we had that already by establishing in practice that if there was a 0 hours contract on a paper, but the situation was that the hours were always there and the person worked regular 35, 40 hours every week for 1 year. So then employment tribunal usually agreed with the employee that it was a regular full-time contract rather than 0-hour contract. So then again, I think it will bring some clarity what is and what is not 0-hour contracts.
James, can we have the next slide, please? Thank you. So the other change that is being brought about under the Employment Rights Bill is work-life balance. It's a big element of employment these days, since flexible working and working from home, particularly since COVID, working from home has become a common practice. And there's currently a right to request flexible working from day one, but this can be refused on eight grounds. The reasons for those will be that there is a burden of additional cost and inability to reorganize work amongst existing staff, an inability to recruit additional staff, a detrimental impact on quality, a detrimental impact on performance, detrimental effect on ability to meet customer demand, insufficient work for the periods the employee proposes to work, planned structural changes to the business. So there is some change to this, but not the reason. The reasons remain as is. That will be carried forward into the new Employment Rights Bill. But what is going to change is that if there is a refusal, then there is an additional burden or additional caveat for the employer, which is, sorry, which is that they cannot they have the employer has to provide that the reason for refusal is reasonable. You cannot just say I'm refusing because it is going to be additional, that it will cost, have additional costs on business. You will have to justify where that additional cost is going to be and the impact of it on the business. For example, therefore, this is reasonable for me to refuse the request. In addition to that, there was talk about, previously there was talk about right to disconnect, where essentially once the employee is outside of working hours, then they had the right to completely disconnect from work, not be available. But that has been dropped and will not become a law. Thank you, Marek. Over to you.
Yes, before we go any further, because I was thinking about this right to disconnect, because now it's very common practice to work from home or even work from anywhere people are. So it is it will be very difficult to implement this sort of legislation in practical way. I think that's why it was dropped, really. Yeah, the next change is about basically Equality Act 2010, the diversity, discrimination, and pay reporting. So for the large to medium employers, they need to report the pay gap between different sexes, women, men, and also to provide sufficient equality and diversity policies. Either that can be part of the staff handbook or separate policies. You may probably have these policies yourself. I hope you have. If you don't have, you need to call us. We can sort it out. So I think now the biggest change is really now for the third party harassment, because I think I remember I had a case before. It wasn't car industry. It was in a restaurant where there was a waitress and there was a specific client coming practically every second day to this specific restaurant, harassing her sexually, making some comments. And then she made a complaint to the employer, where the employer said, well, we don't need to do anything because we're not harassing you. It's a third party client. We can't do this. He's client of the business. So now it will change, because if this potential client will be still keep coming and making those comments after the employee, the waitress, would make such a report, then the employer must do something about it. So they must warn this client not to do this. In practical terms, I just don't know how this is going to work, but this probably will be prescribed in the legislation, I hope. But employers will have a higher threshold of preventing harassment from third parties. So this could be clients of the business, so not specifically employees of the business. So that's the main change. How this works?
Yeah. I mean, along that line, Mirek, I mean, I suppose one of the options for an employer would be to ban that individual from coming to their restaurant, because that would go towards taking all reasonable steps by the employer. And given that a lot of our clients are hospitality sector, it makes sense that that would be one of the options that they will try and exercise. Well, in practical terms, as you said, they can say to the customer that you're banned, but whether that would happen or not is difficult to predict at this,
It's that's what I'm saying, because this is one of the changes that is widely discussed, and we don't know yet how is this going to work in practice, but it will happen. And obviously the last point here states that the sexual harassment is maybe will be qualifying disclosures. It is to do with whistleblowing and protected disclosure, and that will not change. That is still there. We can go to the next slide, James, please.
Thank you, James. So at the moment, I mean, this is about employee voice and representation, and trade unions are considered to be the voice of employees and representing them. Currently, there is no general right for trade unions to access workplace. So, and there are complex thresholds that unions have to meet in order to organize trade union or presence within a workplace. However, at the moment, that's like they need to have at least 10% of employees who are their members. That there is a proposed change to that, and that would be that they only need perhaps about 2% employees who are their members for them to be able to be sort of in an organized way at a workplace. So that's number one. And number two will be that this would give them they will now have, under the proposed employment rights bill, they will have right to direct access to the workplace, which they don't have at the moment. At the moment, their right is limited to having access through an employee who's their member. But they will have direct access to the workplace, and they will be able to try and get collective bargaining at the workplace. So that's what is being proposed. Then comes at the moment, the law requires that an employer provides a written statement or contract of employment, which we suggest is a preferred option, a written statement of employment on day one of a person's employment. This will continue, but there will be an additional requirement, which is that employer will have to notify the employee that they have a right to join the union. And then there were, there were two major trade union laws that were brought during the Conservative government's regime, which was Trade Union Act 2016 and the strikes. These are, Strikes Act of 2023. These two will be repealed, so more power will be given back to the unions. There are other changes that are being brought in relation to trade union, but those aren't necessarily going to impact smaller organizations as much, so I'm not going to be touching them in any detail. Next slide, please, James.
Yeah, so it's we continue with the trade union bills and changes. So the employees currently cannot face any detrimental treatment due to trade union activities. But there was a recent case called Mercer, MERCER, found this only included dismissal. So the change will be the employment rights bill will make this for all detrimental treatment. So other than dismissal and detrimental treatment, I think it's more to do with trade unions activities and protected disclosure combined. Also, there will be some sectoral changes for social care, where there is a currently decided by employer, but this bill will establish that adult social care negotiating body to negotiate pay with providers and unions across the sector. But I would assume this is usually probably would be more to do with medium-sized and large employers. As I'm not quite sure, Nadia, you can tell me this. Would the trade union need to be recognized at the workplace? Because if there is no trade union recognized at the workplace, I would assume that some of this may not be applicable in that strength as we've recognized union places.
I think, because the changes that are being brought and the requirement to have only 2% membership, a lot of these unions will end up being recognized even at smaller places, because 2% of the workforce can be very, if you've got 10 employees out of which 2 employees are union member, then the union will have access to the organization, and I would assume that they would be able to, impact even smaller organizations.
If that will be the case, there will be massive change because now it's different matter because most small business are no recognized union. I only see recognized union in really the large employers, like all the large supermarket chains or the logistic chain, DHL, Asda, and so on. But usually the small employers, that may change then. Yeah, that's interesting.
Yeah, because they are changing the stricter thresholds that the unions have at the moment for recognition and for collective bargaining. That changes with the Employment Rights Bill, so there will be an impact potentially. Again, it's all up in the air, but with the Employment Rights Bill proposed changes. So we don't quite know yet because it depends on what all comes through, but that's the proposal at the moment.
Let's go to the next slide.
So the next slide relates to family rights. And again, this is a significant change. So we all know that people who are on maternity leave at the moment have a right to preferential treatment in a redundancy situation. However, the new employment right bills goes further to strengthen the rights of a pregnant woman, pregnant lady, and who's on maternity leave, and even when she returns from her maternity. So throughout her pregnancy, although you already have a lot of rights during your pregnancy, but these rights are strengthened throughout your pregnancy, maternity leave, and when you return to work. So it's a long period of 18 months where the protection is provided. So if a person, a pregnant woman, is on, if there's a redundancy situation, they will have to be prioritized. A pregnant, a female, or a female on maternity leave, or a person who's returned from maternity leave in the 6 months following maternity leave, they will be protected by law. Dismissal, the proposal, one big change appears to be also about proposal that there will dismissal of such employees will or is likely to be unfair unless there's certain specific circumstances. Now, we need to see what those certain specific circumstances will be. I would think and hope that if it is conduct, if it is a gross misconduct related issue or a conduct issue, that should not be impacted by somebody being pregnant or on maternity leave or following return of their maternity leave, unless it can be shown that it is the person is being or the person's conduct has been impacted because of their pregnancy or maternity. I'm not sure how that would work, but we will have to see how it comes across. But yeah, the dismissal itself of such employees would potentially become unfair. At the moment, also, there's no, the current. Yeah, I was going to say, James, go back to the old slide. Thank you. So at the moment, there is no right to bereavement leave unless an employee's child dies, a pregnant employee's child dies, or an employee's child dies under 18 months, or there is a stillbirth after 24 weeks of pregnancy. But this will become a day one right for employees, and future regulation will specify the relationship that is necessary for this right to be exercised. So bereavement leave right, exercise of bereavement leave will be changing going forward. Currently, employees are eligible to relevant parental or statutory paternal leave after a year of employment. This will also become a day one right. So that is another change that would happen. So eligibility in relation to parental and statutory paternity leave will change to day one right rather than after 1 year of service. Thank you, James.
The next changes relates to sickness, well-being, and disability. So now there is no requirements for menopause action plan. So that will change for the larger or medium-sized and large businesses with 250 or more employees. So they need to produce a menopause action plan as part of the equality action plan. But despite this, you need to watch out because menopause in some circumstances may be classified as a disability. So then, in my view, we already have some case law protection for women who goes through menopause, that they may be protected under different legislation, but there will be definitely change in relation to this. And the another change is, I think the most important, is the statutory sick pay, which for now the first 3 days are usually not payable, so there's no obligation to pay. So the change would be that the statutory sick pay will be payable from day one of a sickness absence. So that's a significant change, of course, especially for small employers. They need to incorporate the cost somewhere.
Yeah. So at the moment, there's no requirement to record compliance with holiday entitlement and pay. So employers are required to give the statutory holiday entitlement, and employees should be taking these holidays. However, there's no compliance requirement of keeping a record of how this has been implemented. This is going to change going forward, and everyone will need to keep a record of holiday entitlement and payment being made for those holidays. So I think it would be a good idea for businesses to start thinking in terms of how that record compliance is kept in place. At our organization, we have a HR software that we utilize for this purpose, and it is quite helpful. So if any one of you don't have something like that, I would suggest that you should have a software of that nature in place that would assist with a lot of your HR compliance. And if you would like us to get you in touch with somebody to the organization that provides ours, then we can do so to assist. The other thing would be that employers will be now, this will be obviously applicable to hospitality sector, but employers will be required to have written tips policy on how the tips are allocated and how it's distributed. So that policy will have to, there will also be scope for, once the tips policy is written, because the trade union will be, their powers are being strengthened, and they will probably be part of smaller organizations as well, or there will be a requirement for trade union consultation, sorry, prior to the first version, that is prior to the first version, and any updates every 3 years. Yeah, next one.
The next one is the time limits for bringing a claim to employment tribunal. That's very interesting, as for now we have 3 months minus 1 day actually to start ACAS reconciliation. So just to give it an example, let's say someone was dismissed today, then there's a 3 months minus 1 day to start some action. Plus, usually the duration of ACAS would be added to the 3 months. So that may, ACAS is up to 6 weeks. So maximum, let's say, is 3 months plus 6 weeks. Plus, sometimes there's extra 1 month from the date the ACAS certificate would be issued. So it is already some time now. So the change will be to change it from 3 months to 6 months, which is significant because let's assume that someone would be dismissed. So then the employer does not know for over 6 months if that person would or wouldn't bring a claim in employment tribunal. It's for and against here. I'm not going to discuss this. I'm just saying that the change will happen for good or for bad. And then another change is limited stays. So basically, a creation of fair work agency. They're going to call it. If that happened or not, I don't know. But what I can tell you, because I'm originally from Europe, I've got European background, so I'm sort of aware about legal differences between Europe and here. So in many European countries, like let's say Germany, they do have this agency where they have powers to enter workplace, and for example, they may check health and safety status of the workplace, or they may check how the employers treat employees, and they've got certain powers to do it. So that's very interesting change. If this would happen or not, I think I will carefully observe this specifically. I don't know what do you think, Navia, about this?
Not sure. I mean, you know, it depends. It could be good and bad both, because it
Of
depends
course.
on how the power is, or what powers would be passed on to such an agency. And with the trade union rights being strengthened as well, the combination can be an interesting situation to see how.
There may be a lot of scrutiny for businesses.
Yes, a lot of scrutiny potentially. So we will see how that goes. But I was looking at, what you've talked about in terms of time limits. So although the time limit for employees to bring a claim is being extended to 6 months, I do not know whether that would be having any impact on the time that an employer will have to provide their response. Because at the moment, if an employee brings a claim, the employer has 28 days to respond to the claim from the date the tribunal sends the claim to the employer. So I'm hoping, and I think generally speaking, that is a very short period that is being provided to employers, because if they don't have lawyers already, in-house lawyers, they have to go and find somebody who can assist them, who can get to the bottom of the whole situation, understand what had happened, and that there can be a long history that they have to respond to. So it can be quite stressful. So I'm hoping that they would, on the back of this, there would be some amendment to that, but there is no proposal at the moment that I'm aware of. I'm just hoping.
Well, that's true. That's a good point, because if the employer has got one claim against them, that's not end of the world. But if there are, let's say, 4 or 5 claims at the same time, and you need to respond to each of them within 28 days, that may be a lot of work and a lot of trouble. So yeah, that's interesting point.
Yes. So, okay. The next slide. How will this affect me? Well, what does this all mean for employers? It definitely means a lot of changes coming our way. We're not sure exactly how each one is going to play. I don't think, well, it does not become law until the bill gets a royal assent. But so we've got some time, but it does mean that it is definitely going to come in force. So some changes are definitely coming, even if some are being dropped. So we need to be prepared. We need to be on top of it. And thank you to all of you who've joined this, because obviously I understand everyone is worried about it, and you're trying to do what you can to get more information about what the changes are or the proposed changes are. And I'm hoping that we can help you through this process, and we will have regular webinar series where we'll go in deeper detail about each of the proposed changes. So yeah, hopefully we can assist you with this process, which can be quite stressful. So that brings us to the end of our presentation. Thank you all for attending our presentation. And if you have any questions that we don't get time for today, please get in touch with us at enquiries@truthlegal.com. If you've got any questions.
Thank you, Navia and Mirek. we've had one question in chat so far. Please, anyone else, be sure to add them in. The question is on bereavement leave. So what is the statutory right? Is it 5 or 7 days? And which family members may be covered? And when is it likely to become a statutory right from? Would either of you like to take that?
So, yeah, I mean, in terms of what family members will be covered, we are not certain at the moment because it will become clearer once the bill is in.
I can answer some of it if I can.
Okay.
Because the current law is 2 weeks paid leave for child death or stillbirth after 24 weeks, limited for miscarriage. So that the new law proposed 1 week for all bereavements, so regardless what it is, so 1 week, and then 2 weeks for pregnancy loss, including miscarriage and similar things. So basically, it will be 1 week for family bereavement and 2 weeks for pregnancy loss. So I think that's the difference. But what exactly we'll get then once the bill is passed, and we'll see.
Yeah, that's what I was saying, that which family members will be covered under bereavement law is still to be seen based on what the Employment Rights Bill would propose. So that is still up in the air and will be clearer later on. But the other bits that you've just mentioned, Mirek, that is what the position would be.
Yeah. Any more questions?
There's just one question for clarification on that. So is 1 week equal to 5 working days? And when is royal assent likely to be?
So are you answering that, Mirek, or shall I answer it?
You started. I'll let you go.
Okay. Okay, so the royal assent is likely to be in 2026. So we don't have the date yet, but it's likely to be in 2026 implementation. In terms of 1 week, that would be, I would say, calculated based on what is the working week of the individual. So if they work 2 days a week, their working week is 2 days. That would be the salary that would be paid. Does that answer the question?
Yes, they said thank you. So let's hope so. There are no other questions at the moment, but if anyone thinks of a question later on, be sure to get in touch with us and we'll answer it to the best of our ability. Also, more webinars will be coming, so check the website for when they will be and what is being covered. As we see the bill develop, we'll be able to give more details and much more certainty about what will be involved with the bill and other legislation that is going to surround it, because a lot of it will be worked out in sort of secondary processes. Thank you all for coming, and thank you, Nafia and Mirek, for presenting. And hope to see you all at the next seminar or webinar.
Thank you, everyone, and thank you, James and Mirek, for assisting.